Alternative dispute resolution is a term to describe various ways in which legal disputes are resolved. These days, courts are filled with cases resulting in delay for justice for parties to solve their cases. And in response to this question of delayed justice, ADR was created. There are different forms of ADR: arbitration, conciliation, mediation, judicial settlement, and Lok Adalat. ADR is legally recognized under Section 89 of Code of Civil Procedure, and this section allows out-of-court settlement. Let us now look into the different types of ADR in detail. Firstly, arbitration. You would ask me, when should I choose arbitration? You have to choose arbitration when there is a disagreement on a particular issue between one or more people. When there is such a disagreement, a third person is involved in this case, who is now called as an arbitrator. He will listen, examine, and look at the evidence of the case and will give a legally valid decision for both the parties. Your arbitrator will give an outcome or a final decision. It is left up to both the parties if they want to agree on the decision or not. Keep in mind, arbitration is the most expensive of all the types of ADR available. Conciliation is the second form of ADR, and it is completely opposite of arbitration. Here, the third person will only suggest and help the parties to come to a conclusion, but the final decision, the parties are the ones who will have to take it. The conciliator will not give a final judgment or will not decide on behalf of the parties. So, in case you and your other party are willing to decide on a common ground, then conciliation type of arbitration is for you. Now, the third form of ADR is called as mediation. Before I talk about mediation, keep in mind it is almost 90% similar to conciliation. Here, there are three groups of people involved: first party, second party, and the third party known as the mediator. In mediation, parties are the ones who are in control of the outcome. The mediator does not make the decision. Conclusion is only done with the parties' approval. It is a very informal process and low cost as well. Fourth form of ADR is judicial settlement. Judicial settlement is recognized by law under Section 89 of CRPC. Here, under this process, either the judge or the higher authority decides the outcome. This is time consuming, and the parties here would have to agree to the outcome or the decision taken by the judges. If one of the parties do not like or do not agree to the decision, then they can appeal the matter in the higher court. Lok Adalat is the last and the fifth form of ADR. If your case is pending in the lower court for many years, then you can refer the matter to Lok Adalat. But one disadvantage in this is, once the decision is given by the judge, it is final. You cannot even appeal to any court in case you are not happy with the outcome or final judgment. The advantage, although with Lok Adalat, is that there is no court fee for this process. Now you have multiple ways to settle your conflicts quickly, as ADR offers immediate justice to you at low cost. It is time for you to now look out for these methods than going through the usual route of filing a case in the civil court. I assume you understood a lot about ADR and you are in the process of taking up one of the ADRs as your option to find a solution to your case, then going through the usual route of filing a case in the civil court. I post regularly on Instagram and Facebook under the Legally Fit Joshiba name. If you found this video useful, hit the like button and subscribe to this channel. It would help me understand that I need to post more videos as such in the future. Thank you so much for watching.